We have Representative Brian Zollinger here and our counsel Brian Smith with Smith Driscoll and Associates, and I am Representative Ron Nate. I represent District 34. Representative Zollinger represents
District 33.
When the legislature convened on January 9th of this year, its members were informed of a $100 million surplus in our budget. Since opening day, the legislature spent up the surplus and borrowed another $300 million for Garvey bonds for roads. And only in the waning days of the legislative session did they pay serious attention to looking at tax reduction. Because of the nearly 10% increases in spending already appropriated over last year's budget, there seemed no way to provide meaningful tax relief this year. The surplus was nearly gone. This brings us to House Bill 67A, the grocery tax repeal bill. The grocery tax repeal would take sales taxes off the table for grocery purchases. It would also repeal the clunky grocery tax credit that we get on our income taxes. Because the money had been spent up this year, the grocery tax repeal wouldn't even begin to take effect until 2018. By large margins, the bill easily passed both chambers of the Idaho legislature. It passed the Senate by 71%, the House by 73%, and was forwarded on to the governor's desk. This was the only real tax relief that the legislature was able to get to the governor's desk this year. Yesterday, the governor the governor informed the Secretary of State that he disapproved of 67A and informed the Secretary of State that he was vetoing the bill. Unfortunately for the governor, but fortunately for Idaho citizens, the governor's veto came too late. House Bill 67 becomes law effectively 12 noon Monday, April 10th, exactly 10 days, except for Sundays, after the Idaho legislature adjourned, sine die, for the 2017 session. The Idaho Constitution is clear. Please allow me to read the important section of the Idaho Constitution. It's Article 4, Section 10, and it concludes like this. Any bill which shall not be returned by the governor to the legislature within 5 days, Sundays excepted, after it shall have been presented to him, shall become a law in like manner as if he had signed it, unless the legislature shall, by adjournment, prevent its return, in which case it shall be filed with his objections in the office of the Secretary of State within 10 days after such adjournment, Sundays excepted, or become a law. 10 days after our March 29th adjournment, Sundays accepted, was Monday, April 10th at 12 noon. This is precisely the time and date for House Bill 67A becoming Idaho law, according to the Idaho Constitution, Article 4, Section 10. We fully anticipate the governor will attempt to argue there is Idaho Supreme Court precedent for his untimely veto by referring to the narrow 3-2 Idaho Supreme Court decision of 1978. However, in the dissenting opinion in the case, Judge Donaldson wrote, and I quote, "Within 10 days after adjournment means exactly what it says. The other way to veto a bill is within 5 days after presentment. In this case, and in our case, the governor did neither. We agree. The Constitution is clear on this matter. Therefore, we urge the Secretary of State to honor his oath of office, to uphold the Constitution of the state of Idaho, and therefore certify House Bill 67 as amended, as mandated by the plain language of the Constitution. Accordingly, we have prepared and submitted this letter asking the Secretary of State to acknowledge the new law of the land in Idaho regarding tax-free purchases of groceries. We are prepared to pursue all legal avenues necessary to ensure the Constitution is adhered to and to make certain the grocery tax repeal takes effect as Idaho law already requires. Rules are rules, and the Constitution is clear. 10 days is the time window, and the governor allowed it to expire. We appreciate the efforts of the Idaho legislature, especially Senator Cliff Bear, who drafted and advanced the grocery tax repeal. We wish the governor had straightaway agreed with the fiscally conservative policy of reducing tax burdens on Idahoans. But we are all fortunate the Idaho Constitution protects all Idahoans from a governor who unnecessarily delays his decisions or plays games with the veto process. This is a historic day for Idaho families. Idahoans will be paying less when they make their grocery purchases. Idaho will be more livable for Idaho citizens and be more attractive to potential Idahoans. Idahoans will have more money to spend on groceries and other goods, the economy will grow, and Idahoans will prosper because they will have more money to keep in their pockets. Thank you.
We fully anticipate the governor will raise that Supreme Court case, and with the letter to the Secretary of State, we're hoping that the Secretary of State will honor his oath of office and follow the Constitution. Should that not occur, as Representative Nate stated, we're fully prepared to pursue all legal avenues, including a lawsuit or obtaining a writ of mandamus. In the event that that happens, we anticipate, and we've spoken with other representatives of the state, we anticipate we'll have 15 to 20, possibly 30, because this is a bipartisan action supported by both parties. This isn't a partisan issue, so we fully anticipate to have 15 to 30 other state representatives, potentially others, join us in the lawsuit and to push, to encourage the Supreme Court to issue a writ of mandamus should the Secretary of State decide not to certify this as law. We'll open it up to questions. If any of you have any questions, we'll be happy to try to answer those.
Could you state the precedent again? The 1978 Senarusa versus Senarusa
Versus Governor Andrews.
Senarusa versus
Senarusa, right.
Do you need a citation for it, or?
I can find it based on that.
And you know, we think precedent also not mentioned is the Hoffer decision of 2016 on the attorney fee issue. As Representative Nate stated, the Senarusa versus Andrus case was a 3-2 split decision. What the Supreme Court did in 2016 with the Hoffer decision on attorney's fees is stuck to the plain language of Idaho Code Section 12-121 and overturned 20 years of court precedent on how attorney's fees were awarded. So we believe with the makeup of the Supreme Court today that they are going to stick to the plain language of the Constitution and have the courage to say this is what the Constitution says and this is how we're going to decide the case. So we fully believe the Supreme Court will decide in our favor should it get to that point.
Brian, let me add also that in the Senarusa case, a 3-2 decision means that there were 3 judges who were in favor of amending the Constitution as opposed to interpreting it, and 2 stood up for the Constitution. There was also the trial judge in that case granted summary judgment consistent with upholding the Constitution. So there were actually, in that case, there were 3 judges who said that the Constitution could not be amended as the way the case ultimately was, and there were also 3 judges who were in favor of adding this provision. I will just note that 2 of those judges, 2 of the 3, were Cecil Andrus appointees, who was a Democrat, and we think that given the current makeup of this court and also given this the Hopper case where they applied a strict plain reading language to a statute that overturned 20 years of case law, we think that we will be successful in reinstituting the actual constitutional provision that the governor had 10 days to get it done. He doesn't get an extra 2 days, and we believe we'll prevail on this.
So the period that's in question are the 2 Sundays that under it's not.
No. I think the governor thinks that he had 10 days from when it was presented to him. But the clear language of the Constitution says that it is 10 days after adjournment. And so, once again, we already know the governor has lost his way with fiscal conservatism. Now it appears he's lost his way with understanding the clear language of the Constitution, or he's miscounted days yet again in terms of when he can submit his veto.
And to be clear, the Senarusa case has added additional days for presentment. So instead of 10 days from adjournment, the Senarusa case says that it's 10 days from presentment, which is a couple of extra days in this case, which he does not have if you follow the language of the Constitution instead of the court amendments in the Senarusa case.
Okay, so I haven't looked up. So what you're saying is the bill's communicated to the governor 2 days after adjournment in the case of this bill, and the governor thinks the clock starts ticking when he gets it. You guys say the clock starts ticking sine die.
Not only do we say it, the Constitution says it.
Right.
But that's exactly right. If you look at the letter that Governor Otter issued with the veto, he puts as the date, he explains it's allowed with the time limit by law The bill having arrived at the office at the hour of 12:05 p.m. on March 31st, 2017, when we actually adjourned sine die on March 29th. So he's going by the date of presentment, which would be correct under the 5-day provision in the Constitution, but not the 10-day provision, which very clearly states upon adjournment, not presentment of the bill.
Okay.
And have you guys spoken, are other legislators, representatives aware that you guys are pursuing this action? What response have you gotten from them?
There are a few others, and they are largely supportive, as are a lot of Idahoans. This is a very popular bill, and so the issue at hand is important for Idahoans, but the constitutional issue is also important to us as lawmakers, and I think to Idaho citizens as well. The Constitution should mean what it says.
Any further questions? Thank you for coming to the press conference.
Thank
Oh,
you.
had one?
Yeah.
Did you have one?
Well, I might make more sense for me to sit down with you guys after, or I could ask it.
Just asking how.
Okay. Well, this probably won't be very good for video.